Livestock. Good evening, everyone. Good evening to all of you. Yesterday we started law of injunctions. That is, as far as Order 39 is concerned. This requires elaborate explanation. Here, I told you yesterday itself that injunction is spelled in two different ways by two different professionals. As far as a surgeon or a doctor is concerned, he knows only one thing called injection, injection. As far as a legal man is concerned, he knows only one thing called injunction. Injunction is also called a preventive relief or protective relief. Here, before we go into injunction, I again take your attention to the common law in England. Previously, as far as the common law courts created by the Queen by a charter issued by Her Majesty, a common law court came into existence. And common law courts comprise of three wings. One is called Court of Exchequer, then Court of Common Pleas, and King's Bench or the Queen's Bench. But as far as common law was concerned, they were deficient in certain aspects. They could not enforce a positive aspect of an agreement, that is by specific performance, or negative aspect. What is that negative aspect? Negative aspect means to prevent a breach or prevent a violation of the breach of contract. Then slowly, what happened was petitions started pouring in to the Queen, and the Queen, at those days, I'm talking about 16th or 17th century, the Queen of England was very, very powerful. Almost the Queen of England had her sovereignty over 2/3 of the nations comprising the world. Then what happened was slowly petitions started pouring in to the Queen for redress. And the Queen found that it was very difficult for her to devote on these legal functions. And slowly that she delegated her functions to her conscience keeper, that is the Lord Chancellor. Lord Chancellor is no more there. Today they are all called prime ministers. So the equity courts stepped in. Then the equity courts came in to fill up the deficiencies in the common law. And the equity courts evolved various doctrines. For example, today we have got specific performance, positive enforcement, and also the negative, that is the injunctions. They are all created by the courts of equity. The courts of equity, they said, we have not come to destroy the law, but we have come to cure the defects as far as the common law is concerned. Because a doctrine, justice should not only be done, but deemed to be done. As far as common law courts were concerned, they were only awarding damages for a civil wrong. Even if a breach of contract is sought to be committed, the common law courts used to grant only wipe the tears of the victim by paying money, directing money compensation to be paid. Please remember, that is not the idea of law, or that is not an object of law, or it is not the object for which a contract is entered into by two parties. For example, suppose an agreement is made and there is escalation of prices and a particular price is agreed upon, and then the seller receives or gets an offer for more money than what was contracted for. Blatantly, the seller used to commit the breach of contract and also pay damages and also some extra money to the victim and get away from that. Then the equity court felt, after all, this is an injustice done to the victim. There must be some methodology through which you can compel people to abide by the contract made by and between them. So that is the reason why the law of injunctions was created. So law of injunctions is a child born out of equity and not found in the common law. Here, suppose you take a case of partition filed by one of the brothers against the other brothers, and one of the brothers is in possession of the property and all the title deeds are in his possession, and you file a suit for partition. And then, in the meanwhile, the brother who has got the title documents and also the possession of the property will try to sell the property in order to see that I do not get my share in the property. So that is the reason injunction comes to the rescue of the victim who can prevent a breach of contract. So that is the object of issuing this type of decrees. So, injunctions are not found earlier in the common law, but they were created by the law of equity. Here, injunctions are normally granted because it's a relief in equity. It's based on two maxims. One who comes to equity must come with clean hands. That is, there shall not be any suppression or there shall not be any concealment of material facts. And you shall not take the other side by surprise. Then the second doctrine was one who seeks equity must do equity. What do you mean by that? One who seeks equity is when you knock at the doors of the court and seek the relief from the court to exercise the equitable relief as far as you are concerned, you must also be above board. That means you must be prepared to perform your obligations which are embodied or incorporated in the contract. Unless these two maxims are satisfied, you cannot knock at the doors of equity and ask the court to exercise the discretion in your favor. So this is a brief history of how law of injunctions came into force. Then Order 39 has got a nexus with the Specific Relief Act. That is section 37, 38 and 39 of the Specific Relief Act. That spells in the Specific Relief Act, it is the three types of injunctions are spelled out. One is mandatory injunction, another is temporary injunction, and another is ordinary injunction. And one more thing is also there called ad interim, ad dash interim, interim, ad interim injunction. These are the three types of injunctions which are postulated in the Specific Relief Act. But as far as the Civil Procedure Code is concerned, Order 39 deals with only temporary injunctions. Then what are the principles which have to be satisfied for grant of injunction? One is a prima facie case, PRIMA dash FACIE, prima facie case. Second one is balance of convenience, and third one is relative hardship. These three ingredients will have to be satisfied for grant of injunction. Then we'll go one by one. What do you mean by prima facie case? Prima facie case means on the face of it, on the face of the record. That is what is called prima facie. Based on facts, based on documents, whatever case you make out, a triable case in a civil court for exercise of equity jurisdiction for grant of injunction is what is called prima facie case. The second one is balance of convenience. What do you mean by balance of convenience? as far as the advantage that is going to be cost to you or accrued to you as a plaintiff should outweigh the hardship that is to be caused to the defendant. That means, based on facts, based on documents, you have got a more probable case than the defendant. That is called balance of convenience. Then, third one is what do you mean by relative hardship? That is, the advantage cost to you will outweigh the hardship cost to the other side, and you will be the worst sufferer in case the relief is not granted. That is what is called relative hardship. The earliest case decided on the law of injunctions was AR 1963 AP 365. Now, AR 1963 AP 365, that was the judgment rendered by Justice Chandra Reddy, who was the Chief Justice of the composite Andhra Pradesh state in 1963. He said all the three ingredients will have to be satisfied in order to be entitled for grant of injunction. But of course, Supreme Court, lot of Supreme Court cases are also there which follow the same principle. Principles will not change, please. I'll put it the other way around. In case you file a suit for injunction, you must be like Caesar's wife. You know, in England, I'm sorry, in Rome, they say the chastity of Caesar's wife, that is Cleopatra, must be above board. That is, you shall not be the wrongdoer. You shall not be the person who has committed the wrong, but complain against the other side. Sir, the other side is the wrongdoer. I have nothing to do with that. It is something like the English proverb, kettle calling the pot black. What do you mean by that? You know, the color of the kettle, that where you store hot water, is black, and pot is also black. One mocking at the other, saying, "Look how black you're looking, how awful you're looking." Then the pot shoots back by saying, "You are yourself black, you are calling me black. How can that be?" So, in other words, the plaintiff should be above board. The plaintiff should be an innocent person. He should be a person who has been wronged or who has been victimized by the other side. Then alone, a suit for injunction is maintainable. Then we come to what you mean by interim injunction. Please remember, today in civil courts, most of the reliefs which are now today feeding the civil court advocates are injunction suits. But before the amendment in 1976, when we had the old code of 1908, whenever you file a suit for injunction, it used to be granted automatically, even without exercising mind or conscience. Courts used to automatically grant injunction. But in 1976, the Act 46 of 1976 brought about an amendment by saying, sir, injunction shall not be granted as a matter of course. It is a discretionary remedy, and whenever injunction is granted, reasons for granting injunction will have to be clearly spelled out by the presiding officer in the order. Then the question arises, sir, then in 1976, they said, the legislators laid down that injunction cannot be granted as a matter of course whenever a suit is filed for injunction and interim relief is sought for, that is for grant of temporary injunction. It is the duty of the court to issue notice to the opposite side and give an opportunity to the other side to file the counter and defense and also their documents, and then alone pass an order as far as temporary injunctions concerned. And that is the reason the courts have evolved a new order called status quo. You know what you mean? Yesterday, I think was one of the students, one of the candidates asked me what is the meaning of status quo. Status quo means things stand where they are. Things stand static. They don't move 1 inch or another from either side. Neither you as the plaintiff can do any act, nor the defendant as the defendant can do any act. So the question is something like, it gives rise to wild interpretations, and that is the reason status quo order is not advisable. But unfortunately, what is happening is the courts, in order to absolve themselves from their responsibility, are granting status quo orders. And it's also provided that in case you file a suit with out of order, urgently you file it in the court. Then you file the out of order petition under section 151 CPC. Then when you file an out of order, it's a duty of the section to check up your file and then enter it in a register called the SR register, or what is called stamp register. Then the Sherestadar or the CMO of that court prepares a note, and at 2 o'clock he presents the note to the presiding officer, who is the allotting judge. Then the allotting judge, what he does is, he himself goes through the plaint and, and, and endorses on the plaint that register the suit. Then the duty of the CMO is to enter it in a register called the suit register, and also check up the caveat register whether any caveats have been filed in respect of that particular claim, and then endorse on the suit that caveat has been filed bearing number so and so, still it is in existence. Actually, when I come to the sections, I'll discuss what caveat exactly means. Caveat means do not pass any ex parte orders without notice to me, that is the defendant. Then if you press more, what the court does is, it passes a status quo order. Status quo order means neither you can interfere nor the other side can interfere. Things stand where they are. Or in labor law language, it is called the doctrine of laissez-faire. LAISSEZFAIRE. The things stand where they are. Here, then whenever you press more, whenever an interim injunction is sought to be granted by the court, in an exceptional case, the court has to pass a detailed order. Court has to pass a detailed order and give reasons why issuance of notice to the opposite side will frustrate the very existence of the suit. So reasons have to be given by the judge when interim injunction is granted in exceptional cases. And because you've got a maxim called adi alteram partem, that is, no man should be condemned unheard. An opportunity has to be given to the defendant to file his counter and file his objections, and also file the necessary documents which supports his, her, or their case. And then once, suppose, let us say, an injunction, temporary, an ad interim injunction is granted, it cannot be given for an unlimited duration of time. It will be given only for 3 days or 4 days or 7 days. In the meanwhile, if injunction is granted, the duty of the advocate who appears for the plaintiff is to file an affidavit under Order 39, Rule 3, what is called compliance affidavit. He must send the copies of the plaint, copies of the petition, copies of the material papers by registered post to the opposite side, and file an affidavit that he has complied with the provisions of Order 39, Rule 3. Once he complies with the provisions of Order 39, Rule 3 and files an affidavit into the court, the orders of injunction is communicated to the opposite side, and a copy of the order is also sent to the party. Please remember, you as an advocate for the petitioner also has got a right of filing a memo into the court. Sir, please grant me a carbon copy of the injunction orders that has been issued. As a matter of right, you are entitled for a copy. That's what the civil rules of practice provides. Then once an interim injunction is granted, suppose, let us say today we are on 23rd or 24th, let us say tomorrow is Monday, 24th, injunction will be granted up to 30th June 2024. Then your duty as an advocate for the plaintiff is to file an extension petition under section 151 saying, sir, on this particular day you have granted injunction, interim injunction has been granted, it is operative till today, please extend the orders of injunction till such time the defendant files a counter. Then periodically, when the matter is adjourned from time to time, please bear one thing in mind as an advocate is you shall not fail to file an extension petition. If you don't file an extension petition, please remember the order works out on the day when it is posted. So don't take it for granted that once you get an interim injunction, it is permanent. No, it is only given for a limited duration of time to satisfy the ego of your client and your arguments which you have advanced before the court. Then the next step is when the other side files a counter and also files the documents in support of his defense, then arguments are heard on both sides. Then once arguments are heard on both sides, documents are filed, then in that case it's a duty of the court. According to the High Court circular, in every High Court, the documents which are marked in support of their respective cases have to be marked as exhibits. And then once the arguments are heard, then the court proceeds to pass. Don't interpret it by saying judgment. It is not a judgment. It is an order passed in an interlocutory application. It is called an order. Then the judge, what he does is when he hears the arguments, he goes into the pleadings, that is the IA pleadings as well as the counter, as well as the facts raised therein, and the defense set up by the defendant looks into the facts, looks into the documents, and after hearing the arguments and the case law that has been cited, he pronounces his order. That is what is called an order in respect of that interlocutory application. And all applications filed along with the suit which does not form part and parcel of the pleadings are called interlocutory applications. INTERLOCUTORY. And in common parlance, it is called IA. IA means interlocutory application. Or you can understand it this way by saying it's a miscellaneous application. And whenever you file an IA, it has to be supported by an affidavit. Then, once the order is passed, the interim injunction that is already granted in your favor, if the court agrees with you that you have got a prima facie case, balance of convenience and relative hardship, the court makes the order absolute. That is, the interim injunction gets converted into a temporary injunction. And sir, what is the lifetime of this temporary injunction? Till the suit is disposed of, the injunction will be valid. Injunction will be in subsistence. Then the question arises, sir, if I am the respondent, suppose the injunction petition is allowed, what is my relief? Please remember, you have got a provision in the CPC called Order 43. When I come to that, I'll tell you. But anyhow, since I've referred it, Order 43 read with Section 104, which says appeals against orders. They are numbered as CMA. CMA means Civil Miscellaneous Appeal. Then you file an appeal before the district court or the high court as the case may according to the jurisdiction. And then when you file the appeal, you also file an application or what is called interlocutory application to suspend the orders of the lower court till the disposal of the appeal. Then what is the duty of the appellate court? The appellate court issues notice to the respondent, that is a person who opposes your appeal. And the opposite side, whenever stay is sought, the opposite side has got a right of opposing your stay petition. Suppose the court feels, sir, please avoid your cross talk, please. Suppose the court feels that the appeal is maintainable, or let us say the lower court has committed mistakes, then in that case, it can correct the mistakes committed by the lower court. And it allows the appeal and sets aside the judgment of the orders of the lower court. So, first and foremost is, once an CMA is filed, it is a duty of the court to call for the records from the lower court. And once the records arrive, the appellate court is seized of the matter and hears the arguments on both sides. And after hearing the arguments in the appeal, the court has got the power either to set aside, modify, modify, vary, or confirm the judgment of the lower court. In 90% of the cases, I could tell you, the court confirms the orders of the lower court. Why? Because it is easier to confirm than to dissent. Why, sir? Because if I want to disagree with the findings of the lower court, I will have to burn my midnight oil and think about it and give my reasons. I said, why should I bother? That is the attitude of the appellate judges today. But anyhow, I don't want to criticize because I am part of the bar. So the question is, once a temporary injunction is granted, the opposite side has got a right of filing what is called a CMA. CMA means Civil Miscellaneous Appeal, and it is normally filed under the provisions of Order 43, read with Section 104. Then the question often arises that suppose, let us say, the injunction application is dismissed by the lower court after hearing both sides. Then in that case, sir, the person who is the unsuccessful party also can file an appeal under Order 43, read with Section 104 CPC. So these are the remedies. Suppose, let us say, the CMA also goes against you. Then you got a further right. You can file a revision before the Honorable High Court under the provisions of Article 227 of the Constitution of India, and a revision can be filed. Under what circumstances revision lies and all, we'll discuss it when I come to that provision. So these are the various facets of injunction. Now we come to what do you mean by temporary injunction. Temporary injunction means that is what is governed by the Civil Procedure Code. Order 39 deals and discusses only about temporary injunctions, please. Here, as far as Order 39 is concerned, once the arguments are heard on both sides in respect of the injunction application, suppose the court is satisfied that the case is made out, it grants temporary injunction. And the life of a temporary injunction is till the suit is disposed of, the injunction subsists. But please remember, in an IA or an interlocutory application, no evidence is laid on both sides, unless in exceptional circumstances. But it's the duty of the court to mark the documents filed on both the sides before giving its order, before hearing the arguments. Then normally in an interlocutory application, no decree is prepared. Please underline this, please. No decree is prepared. What they prepare is decretal order. It's a one-line order. It says the application filed by the petitioner is hereby dismissed or is hereby allowed, and the injunction ordered earlier is made absolute. That means your application, you have succeeded. Dismissed means the court has disagreed with you and they are not satisfied about the facts, they are not satisfied about the documents, and the court negates your pleadings, your statement, or your arguments. Of course, I told you can file an appeal and then revision also. Then we come to what is called perpetual injunction. What do you mean by perpetual injunction? Perpetual, the word perpetual means permanent or forever. As far as perpetual injunction is concerned, it is only in the end. After evidences are laid on both sides, after arguments are heard on both sides, after written arguments are filed into the court proceeds to give its final verdict or tirpu or tirmanam as they call it in Telugu, vis-a-vis the pleadings, facts, documents, inconsistencies, contradictions, and the issues framed, and the case law that has been cited by both the sides will be discussed by the court, and findings will be given in respect of every issue. And then, once the court posts it for judgment, it gives its final verdict. And that is what is called, I think when I discussed Order 20, I discussed it also. It is called a judgment. That is, pronouncement made by a judicial officer vis-a-vis the facts of the case is what is called a judgment. Or dicta or pronouncement of a presiding officer vis-a-vis the facts of the case is what is called a judgment. And then within 7 days, you have got a right of filing your fee certificate or memo of cost If cost has been granted, you have to certify whatever. I mean, in the memo of cost, you'll have to say what is the court fee paid, how much you are paid towards process, how much you are paid for preparation of process, how much you are paid for preparation of the papers, typing charges, then advocate's fee, so on and so forth. In the same way, the respondent also can file the memo of cost into the court and also the fee certificate. And then then the judge says, given under my hand and seal on this the day of so and so. And the judge signs the judgment and also puts a seal as far as the judgment is concerned. Then within 7 days, the MC or what is called memo of cost and the fee certificate has to be filed. After they are filed, what the court does is it prepares a decree. I tell you, and I think in the earlier classes I said what a decree means. Again, for the benefit of many people who have not attended the earlier lectures, I will tell you what decree means. Decree in your civil procedure code does not give a proper definition. It only says sum and substance of the judgment is what is called a decree. Or you can say it's a distillate of the judgment. To give a concrete example, suppose you go to a sugarcane dealer and you want to order for a sugarcane juice. Then what the sugarcane dealer does is he crushes the cane and extracts the juice from the cane. Then he puts a filter, filters the juice, the residue remain on top, and you get the solution down. That solution which you get, which you consume, is what is called a decree. Are you able to understand, please? The filtered juice which you get after filtering it, when the residue remains on top, the juice which comes into the glass is what is called a decree. And what is executable in a civil court is a decree and not a judgment. Then, sir, once the court pronounces its order, it pronounces a judgment. If the plaintiff succeeds based on the facts and documents and the admissions and the inconsistencies and the contradictions and the case law cited on the subject and the various documents filed and marked as exhibits, the court decrees the suit of the plaintiff. What do you mean by decreeing the suit? That means the court upholds the case of the plaintiff. And suppose the court is dissatisfied with the facts, with the documents, and also the various inconsistencies in the facts as well as in the documents, and also the case law which has been cited by the opposite side, the court dismisses the suit. And as far as cost is concerned, it is a discretion of the court whether to grant cost or not to grant cost. As a matter of right, court cannot grant cost. And please bear one thing in mind: once a permanent injunction is granted, it is a judgment in rem. That is jus in rem. That's what is called in Latin language. Jus in rem. Jus, J-U-S space in I-N space rem, R-E-M. That is a judgment for the entire world. That is what is called jus in rem. And then suppose you are aggrieved by the judgment and decree of the lower court, which dismisses your suit, or so on and so forth, you have got a right of appeal to be filed before the superior court, either the district court or the high court. It is filed under the provisions of section 96, read with order 41. So whenever a judgment is passed, either agreeing with you or disagreeing with you, when the suit is decreed, the defendant has got a right of filing an appeal under section 96, read with order 41. That is what is called regular first appeal. It's a statutory right given to a party. And suppose the suit is dismissed, the plaintiff has got a right of going to the superior court under the same provision of law. Then within what time an appeal has to be filed, sir? If it is going to be a decree from the lower court where the value is less than 35 lakhs, then an appeal lies to the district court. Please remember that is the amendment that has been brought about. Earlier, it was 20 lakhs or 10 lakhs. Now it is 50 lakhs, 35 lakhs, 35 lakhs. An appeal can be filed to the district court. But suppose it's more than 35 lakhs, you have to file an appeal in the high court. Then of course, when I come to appeal, I'll discuss it. So if your suit is decreed, you don't bother about it. it comes in your favor, you don't bother about it. But suppose the suit is dismissed, you have got a right of appeal, which is a statutory right, which you can file it before the appellate court, be it the district court or the high court. Then, suppose the defendant is aggrieved by the decreeing of the suit, he has also got a right of filing an appeal under section 96, read with order 41. That is called regular first appeal. Then the question is, suppose let us say a temporary, interim injunction is granted or a temporary injunction is granted, and the other side violates the injunction order and tries to perpetuate the nuisance which he is doing. Then in that case, there is a provision called Order 39, Rule 2A. Order 39, Rule 2A, which means you can punish or you can ask the court to punish the assailant, that is the person who has violated the order or disobeyed the orders of the court under Order 39, Rule 2A. In that case, what happens is when such a petition is filed, the court gives an opportunity to the other side to file the counter and then hears the arguments and then passes an order if it agrees with the contention of the petitioner that really the order has been disobeyed. Then in that case, the respondent has to face the consequences of paying the fine or suffering imprisonment. That is Order 39, Rule 2A. In short, you can call it as contempt. Then the question arises, suppose let us say you obtain an injunction or interim injunction or temporary injunction, whatever it may be. Sometimes what happens is, please remember, I tell you what are the acts which you have to complain for grant of injunction. You say that is the other side, that is the respondent is trying to construct, or let us say the respondent is trying to construct, about to construct, apprehended to be construct, and also close the common passage or the conservancy lane, which is called in the engineering language as SERI, SERI. Please remember, in places where you don't have drainage, underground drainage, there is a 5 feet passage which is left for letting out your drainage water and rainwater. Or let us say he is trying to interfere with your position, or he is trying to do a wrongful act which he has already put it to motion, and if it's not stopped and the mischief is not snipped in the bed, the petitioner will suffer great loss. But in spite of the injunction being granted, the other side proceeds with the construction, affects your rights. Then in that case, please remember, you must always be on guard. You must amend your plaint and ask for an additional relief, saying that ask the other side, sir, please direct the other side to remove the offending structures or the offending acts which he has committed. Unless you amend and correct your plaint and ask for that additional relief, there is no point in taking any decree. Even if you succeed, the perpetual injunction only will be a paper decree without any effect. So that is the reason we must ask for amendment and ask for an additional relief of directing the other side to remove the encroachment or remove the wrongful act. What is that? Then if you do that, you can get a concrete decree tomorrow and then you can execute it also under the provisions of law. Then the next type of injunction that is contemplated is mandatory injunction. MANDATORY, mandatory injunction. It is not covered by the Civil Procedure Code, but it is covered by the Specific Relief Act of 1963. What do you exactly mean by mandatory injunction? Mandatory. It comes from the word mandate. Mandate means order. Order means command or compel the other side to do a thing, which undo a thing which he has done. Then what I told you now, I gave you an example also. Suppose in spite of an injunction order, the other side violates the order frequently. Then in that case, you can ask the court to issue a mandatory injunction to put you back into the same position which you were there at the time when the temporary injunction was granted. That is as far as temporary injunction, ad interim injunction or perpetual injunction is positive in nature, but negative in nature. But as far as mandatory injunction is concerned, against your acts of commission and omission which you have committed, you want the other side to be punished, or you want the other side to undo that particular mischief. That is what is called mandatory injunction. Suppose I'll give you an example. Suppose, let us say, there's a landlord and tenant. The landlord, in order to see that the tenant vacates, removes the electricity meter from the tenanted premises. And the tenant has been deprived of usage of electricity. Though he has been regular in payment of electricity charges, he has been deprived of the electricity. Then he can ask for mandatory injunction to direct the other side to request the electricity board to put back the meter in the same position which it was before it was disconnected or removed. That is, for a grant of mandatory injunction, the remedy should have been lying with you. It's not a new relief, but it has arisen because of the subsequent acts of omission which you want to be corrected. Then you can get a positive relief from the court. That is what is called a mandatory injunction to remove the offending structures or to undo the mischief which has been committed during the pendency of an order for temporary injunction. The mandatory injunction is normally granted in exceptional circumstances. Sir, then you can ask me a question, sir. Under what provision of law I must ask for mandatory injunction? Please remember, mandatory injunction, though you file an interlocutory application, mandatory injunction, the principles that govern mandatory injunction is Section 39 of the Specific Relief Act. Temporary, as far as Order 39 is concerned, it does not deal with mandatory injunctions. But the principles which have to be satisfied are the same. Prima facie case, balance of convenience, and relative hardship. These three ingredients will have to be satisfied for grant of injunction. Then suppose, let us say, you are permitted to amend your plea and add the relief of mandatory injunction. Court permits you to do so. But please remember, the offended party can always prefer an appeal or revision as the case may be before the superior court. Suppose, let us say, Chakravarti, please. As far as the other side is also concerned, the other side also has got the same relief which the petitioners has. So this is as far as interim injunction is concerned. Again, summarizing it, interim injunction is granted only for a limited period, subject to notice going to the other side, compliance of the order of injunction, copies being sent. Then after that, both the sides are heard and an order is passed. And then the injunction order, interim injunction, which is granted, has to be extended from time to time till the counter is filed. If you don't file an extension petition, it works itself out. Then if both the arguments are heard on both the sides, based on facts and documents relied upon by both the sides, and after hearing arguments on both sides, the court pronounces its order, the interim injunction gets converted into a temporary injunction, which will be in subsistence till the disposal of the suit. Then, in case either party is aggrieved by the order passed by the court, then a miscellaneous appeal can be filed before the superior court under Order 43, Section 104. Suppose the plaintiff or the petitioner succeeds in getting an injunction, then in that case, the interim injunction that is already granted will be made absolute and your petition will be allowed. And suppose you don't succeed, the court will vacate the interim order that is passed in your favor and dismisses your application. Then you have got a right of filing an appeal under Order 43, that is appeal against orders, and read with Section 104. Then suppose, let us say, an injunction is granted after hearing both the sides, the defendant is agreed by that order, he can also file a miscellaneous appeal before the superior court under Order 43, read with Section 104. That is the first scenario. The second scenario is, suppose an injunction order which is granted by the court after hearing both the sides is violated by the other side or disobeyed by the other side, then in that case, an application can be filed under Order 39, Rule 2A to punish the offender for disobedience disobedience or contempt. That is Order 39, Rule 2A. But please bear one thing in mind: if an injunction is granted, it is your duty to send the copies of the petition, plaint, and the material documents on the other side. But please remember, some of the advocates commit a mischief there. They only send blank papers, they don't send the papers, but they file the postal receipt. But please remember, the other side, when he wants to go through it to prepare the counter, he does not have anything. Then to the court, sir, no papers have been served on me. Injunction has to be vacated. Suppose you play with the court, your injunction already granted can also be vacated. Then we dealt with what is called temporary injunction. Suppose hearing both sides, the court agrees with the petitioner, agrees with the defendant, passes an order accordingly. Then suppose, let us say, during the pendency of injunction, the other side proceeds with the mischief which he has already started or is trying to complete it. Then in that case, you can ask the other side to pull down the structures or remove the mischief which he has done in spite of an injunction being passed. Then that also is subject to an appeal before the superior court, as the case may be on either side. This is what all is concerned with injunctions. Then we have got what is called copyrights, patents, and trademarks. There also, but please remember, as far as copyrights means, suppose I write a book, you have no business to copy my book and make it known that it is your work. Or let us say I obtain right as far as the copy is concerned without my permission. You cannot imitate and then prepare a book which is almost similar to my book. Then patent. What do you mean by patent? For example, you've got the Coca-Cola, Pepsi-Cola, Campa-Cola and all. They acquire a considerable reputation and goodwill in the market. Suppose I once it is patented, and then what I do is I try to misuse it, and instead of Campa-Cola, I call it as Simpa-Cola. But the design of that bottle, the contents of that bottle, the label which is put on that, the stopper which is put, is almost similar to my design. And the patent which I have obtained, no one can copy my patent and then make it known that it is his product. That is what is called patent, violation of patent rights. Then you then you have got trademarks. For example, suppose you have got your ghee, butter, so on and so forth. They also acquire what is called a domain name, and they are registered as a trademark. Please remember, I cannot copy it and duplicate it and then try to fool the public or the gullible public, where the reputation of the trademark holder is tarnished. Then it is a violation of trademark rights. Then they are all called intellectual property rights, IPR, as they call it. Now it's a litigation in the market. Then in that particular case, I can approach the civil court, that is preferably the principal district court, and ask for injunction and also damages. I cannot go to a lower court and then ask for this violation of patent, copyright, or trademark. I have to go to the district court and then file a regular suit there and then question the violation of the copyrights, patents, or trademarks. Only the district court is competent to hear such matters. So this is as far as injunctions are concerned. Then we go to Order 40. Order 40 speaks about what is the appointment of receivers or receivers. When is a receiver appointed, sir? Suppose a money suit is filed, the defendant has got means and capability to pay your debt, but he is trying to collect the rents, he is trying to get the profits, or he is mismanaging it, and where the plaintiff feels that he is not going to get any amount, even if he proceeds in execution, then in that case, he can request the court, sir, please appoint an advocate, receiver advocate, who can go to the spot, take charge of the assets, take charge of the liabilities, and also try to collect the rents, collect the profits, then deposit the rents or profits into the court, or administer the property for the benefit of creditors. And in those circumstances, a receiver can be appointed under Order 40. Again, I repeat, sir, when a property is being misused, when the rents are being collected by the JDR or the defendant, or the profits are being collected by him, but no part of the amount is paid to the plaintiff, then in that case, the plaintiff can request the court to appoint a receiver to take charge of the property, administer the property, collect the rents from the property, collect the profits from the business of the property, and also administer the day-to-day affairs of the college or the school or an institution concerned. And then, for all practical purposes, he is the person who represents the institution, and then whatever fees is collected, whatever profits is collected, whatever rents are collected, and suppose that institution is due and payable some amount to the plaintiff, that amount has to be deposited into the court from time to time. This is what is called receivers. Much importance need not be given to this particular provision, please, because in real practice, it is a very rare application. Then we go to the most important provision called a first appeal, that is filed under Order 41, read with Section 96. Order 41, Section 96. Again repeating it, Order 41, Section 96. What are the contents of an appeal? On top of it, you say, like plate, I'll give you the ingredients. Memorandum of grounds of appeal under Section 96. Memorandum of grounds of appeal under Section 96, read with. Memorandum of grounds of appeal under Section 96, read with Order 41, Rule 1, CPC. Memorandum of grounds of appeal filed under Section 96, read with Order 41, Rule 1, CPC. First thing you mention is the description of the appellate court in the court of the principal district judge, Medchal Malkajgiri district at Malkajgiri, or you say in the court of the chief judge, City Civil Court, Hyderabad, or in the court of the principal district judge, Khammam. Then you say all appeals on the appellate side are numbered as AS. AS means appeal suit of whichever year it may be. Then below that, you say against. Below that, you say against. Then you give the suit number against which the appeal is filed, OS number of so and so. Then in the bracket, you say, as per the against the judgment and decree of the first junior civil judge, Malkajgiri, dated so and so. Then end the bracket. Then you give the name and address. Give the names of the person who files the appeal. The person who files the appeal is called the appellant, and the person against whom the appeal is filed is called the respondent or is called the respondents. Then down, you mention the cause title of the lower court, in the court of whichever court it is, lower court, and then you say OS number so and so, how the parties are described in the lower court, who is the plaintiff, who is the defendant, you clearly mention it, and then after that, you proceed by writing the grounds. First and foremost, as advocates, you know, you say the appellant above name begs to state as follows. 1. Address for service of all processes and notices on the appellant is that of his counsel, so and so is address. Then, you know, under the new regulations, the advocate also is to give his cell number and also his email number and the email number. Then next one is the address for service of all summons and notices on the respondent is the same as given above. Given in the cause title. Third one is being aggrieved by the judgment and decree of the whichever court it is, dated so and so, in OS number so and so, the appellant begs to file a copy of which is filed herewith. The appellant begs to file this appeal on the following amongst other grounds. Then you come to the grounds. Please remember, it is preferable when you write the grounds, first give the brief facts of the case in the form of paraphrasing it, and the defense taken by the other side also. Then after that, the various grounds, that is, the order, the judgment and decree of the lower court is against the law, materials and evidence on record. Then second one is the lower court erred in basing its judgment on surmises and conjectures. What do you mean by that? ఏదో అనుకున్నాడు ఏదో రాశాడంటే రామాయణం వినేసి రాముడు సీత ఏమైందని రాశాడు అందుకే ఆ గ్రౌండ్ ఒకటి తీసుకుంటాం. Then third one is you say the lower court has not properly examined and interpreted the various documents filed in the lower court. Then fourth is the lower court has not examined the contradictions, admissions, and inconsistencies in the evidence of so-and-so witnesses while disposing of the suit. Then the lower court has not examined and interpreted the case law that has been cited by the appellant during the course of the hearing. Then next one is you say that the lower court has, without any reasons, shut out the relevant evidence which is to be led in the case and disposed of the matter in a cursory manner. Then next one is all other grounds of appeal, as far as facts and law are concerned, will be raised at the time of hearing. Next one is the appeal is filed within time and within the period of limitation, as the copies were applied while CA number so-and-so and copies were obtained on so-and-so date, and the appeal is filed within 30 days or 90 days as the case may be. Next ground you say the appeal is valued for the purposes of court fee and jurisdiction at so-and-so. Again, here, what is the valuation you have to give? There is one section 49 in the Suits Valuation Act which says whatever court fee is paid in the lower court, the same court fee has to be paid in appeal also. Then we say that, then you say the uprier clause. You say the appellant therefore prays that the judgment and decree dated so-and-so in OS number so-and-so, dated so-and-so of so-and-so court be set aside and the appeal be allowed with cause throughout. Then please remember one thing, the memo of grounds need not be signed by the appellant. It can be signed by you as the counsel also, and you say whichever place the appeal is filed and then the date of it and the docket. And what are the papers you have to file along with the appeal is, you must file the copy of the judgment, you must file the copy of the decree, and preferably, if you want to rely on some inconsistencies and contradictions, you can file what is called the evidence copies. Typed copies also you can file, or even the certified copies of the evidence which is recorded by the lower court can be filed along with the appeal. Then the case law which you want to proceed or which you want to cite, which has been negated by the lower court, even that you can file. Nowadays, you are allowed to file Xerox copies of the judgment also. I mean, the case law also. They are not relying on the books being given. And then that also you can file. Then suppose, let us say, in the meanwhile, you are apprehending disposition in an eviction suit where the plaintiff has obtained a decree before the lower court, you are a tenant. Then you can ask for what is called for stay of execution of the decree under Order 41, Rule 5, bracket 2. Order 41, Rule 5, bracket 2, CPC. You can ask for stay of execution of the eviction order under Order 41, Rule 5.2, or you can ask for stay. What do you mean by stay, sir? You want the judgment and decree of the lower court to be kept in suspended animation till such time your appeal is heard. That is to be filed under the provisions of Order 41, Rule 5, bracket 2. It can be regarding other appeals also, where case stay petitions can be filed, and is normally filed in the form of an interlocutory application, then an application supported by an affidavit under Order 41, Rule 5, bracket 2, CPC, stay petition can be filed. Then after that, the next step is, once the appeal is filed, the appellate court calls for the records from the lower court with proper index. And once the records arrive in the appellate court, the matter is heard threadbare on both sides. That is, the appellant as well as the respondent. You can argue anything that what you feel, where you are aggrieved. Then, after your hearing is over, court passes passes a judgment as far as the appeal is concerned. The appellate court, on consideration of the records and the grounds of appeal and the pleadings before the lower court and the evidence that is recorded by the lower court, the inconsistencies and the admissions and the findings on the issue, can pass a judgment either allowing your appeal, confirming the judgment of the lower court, or setting aside the judgment of the lower court, or modifying the judgment of the lower court, or varying the judgment of the lower court. These are the four options that are open to the appellate judge. And then he says, given under my hand and seal on this day of so. So he puts his signature and then also puts a seal. Then along with the judgment, a decree is also prepared, and decree also has to be filed. The fee certificate or the memo of cost has to be filed within 7 days, and then the decree is prepared by the appellate court, and then matter ends there. But sometimes it so happens, sir, the documents which you have filed before the lower court have not been considered, or there are certain additional documents which have got a material bearing as far as the case is concerned, and these documents are just done proper for proper appreciation of the appeal. Then in that case, you can file an interlocutory application under Order 41, Rule 27. That is, petition for additional evidence has to be filed under Order 41, Rule 27. Please remember, most of the advocates, what they do is, they say Order 7, Rule 14, bracket 2, or they say Order 8, Rule 2A or Rule 3. Please remember, those orders don't apply as far as appeals are concerned. As far as appeals are concerned, additional documents which are filed has to be filed under Order 41, Rule 27 CPC. Then the other side will be given an opportunity of being heard, filing the counter, and arguments are heard, and then your additional evidence petition will be considered. Or at the time of your appeal being disposed of, suppose the appellate court finds that the additional documents are just unnecessary, it formulates the issues, sends it to the lower court, and directing the lower court remands the case to the lower court and asks the lower court to record the evidence and give its findings as far as the remand order is concerned. Then you've got a further right of appeal and so on and so forth. Then you say, suppose, let us say, your appeal is dismissed for default. The counsel for the appellate or the appellant is not present on the day when the appeal is called. Or let us say the respondent or the respondent's counsel is not present on the day when the appeal is called. Then what is the provision, sir? Order 41, Rule 19 CPC says you can always file a petition under Order 41, Rule 19, asking the court to rehear the matter. Please remember, appeal cannot be disposed of in a cursory manner. According to the whims and fancies of the district court, it cannot be disposed of. Most of us do not know that there is a provision called Order 41, Rule 19, which says in case the matter is decided ex parte, an application can be filed under Order 41, Rule 19, asking for rehearing of the appeal. And one basic thing you must remember is, appeal is supposed to be a continuation of the suit. Continuation of the suit means whatever applies to the suit also applies to the appellate court or to the appeal. I think with this we'll stop and we'll come to the interaction time, please.
Sir, good evening, sir.
Good evening.
Sir, shall you explain the particulars of counter, sir?
Counter.
Counter, sir.
See, counter is nothing but whatever amendments are made by the petitioner in the petition or the affidavit, point by point, fact by fact, paragraph by paragraph, you give a reply to it. The reply or the defense which you set up in your defense is what is called a counter. And counter is of two types. Counter affidavit. Counter affidavit is sworn and signed by your client, that are deposed by your client. That is called a counter affidavit. But a counter filed by the advocate when the party is not available Only signed by the advocate is what is called a counter. Counter means a reply to the petition filed by the opposite side regarding the facts or averments raised is called a counter. Am I making myself clear to you, please? Your doubt is clear. Next.
Any more questions, sir? Anybody?
Sir, good evening, sir. Myself is Jamuna Siwari.
Yes, madam.
Sir, may you explain once again Order 41 and Rule 19?
Yes.
Just now you explained.
Yes. Order 41 Rule 19 is, suppose let us say on the day fixed for the appeal, the appellant or the counsel is not present, or the respondent or respondent's advocate is not present, then the court has no other alternative than to dismiss the appeal or set the respondent ex parte and proceed accordingly. But Order 41 Rule 19 says the appellate court cannot dispose of an appeal in a cursory manner. It has to hear both the sides. So instead of asking for setting aside the order, you can file a petition under Order 41 Rule 19. Please rehear the matter. I am now present and I was prevented from appearing on the other side and on the other day. Please try to hear me again. Rehear the appeal. That is the Order 41 Rule 19. But here you have got Order 9 Rule 7 earlier. That is where the respondent, the defendant is set ex parte. Order 9 Rule 9 is when the plaintiff is absent, the suit is dismissed for default. When you ask for restoration as far as plaintiff is concerned, and when you want the ex parte orders to be set aside, you ask for your ex parte order to be set aside. Or if an ex parte decree is passed, you want the decree to be set aside under Order 9 Rule 13. Also, you file Section 5 petition to condone the delay, if any. Then in the same way, as far as Order 41 Rule 19 is concerned, if the appeal is disposed of without hearing you and you show sufficient cause why you were prevented from appearing on that particular day, court has no other option than to rehear the appeal again. Am I making myself clear to you, please? Yes?
Yes, sir. Thank you, sir.
Welcome. Next.
Good evening, sir. I am Balaji.
Yes, ma'am. Yes, sir.
Sir, I have not complied Rule 3 within 24 hours. Stipulated period.
Yes.
What is order remedy, sir?
Then if you are not complied with that, you have to file a petition for delay and show why you had not done it. Next day also you can file it, but delay petition has to be filed, sir, saying that by inadvertence or by pressure of work you could not do it. Court can always extend time.
Thank you, sir.
Welcome. Yes.
Anyone?
Hello?
Yes. Please go ahead. Mr. Nagachandram.
సార్ నమస్కారం సార్.
నమస్కారం అండి, చెప్పండి.
ఇప్పుడు రిజిస్ట్రేషన్ యాక్ట్ లో సెక్షన్ 72 ప్రకారంగా వాళ్ళు రిజిస్ట్రేషన్ వాళ్ళు పెండింగ్ పెట్టుకుంటూ రిఫ్యూజల్ పంపించారు. అయితే దాని మీద హైకోర్టులో వేసాం పిటిషన్.
డబ్ల్యూపీ
చేస్తే హైకోర్టు కూడా పెండింగ్ పెట్టిండ్రు. అసలు దాన్ని సేమ్ అపార్ట్మెంట్ లో సేమ్ ఫ్లోర్ లో బిహైండ్ ఫ్లాట్ ఏమో ఆల్రెడీ రిజిస్టర్డ్. బట్ అవర్ క్లయింట్ ఫ్లాట్ ఏమో నాట్ రిజిస్టర్డ్, రిఫ్యూజల్ పంపించారు. దానికి ఇప్పుడు రిజిస్టర్ ఆఫ్ డిస్ట్రిక్ట్ పోయి కంప్లైంట్ పెడితే మీరు అయితే మేము ఆలోచిస్తామని పెండింగ్ పెట్టిండ్రు. అసలు ఏం చేయాలి సార్ దానికి రెమెడీ చెప్పండి.
Your writ is still pending. Is your writ pending?
Refusal notice పంపించారు వాళ్ళు.
Sir, notice పంపిస్తే you can say you cannot have 2 yardsticks for two different flats in the same building, and it has been registered as far as the other flat is concerned. I have complied with all the requirements. Necessary stamp duty has been paid, and also there is no embargo as far as registration is concerned, or no restrictions as far as registration is concerned. It has been improperly refused or kept pending. Please direct the registrar to register the document. You can file that document which has been registered of your neighbor. Are you able,
Okay.
are you
Our
able,
district is terminate.
you can file it in the High Court itself by way of an application and file that document.
Okay, sir.
Yes, next.
Aruna garu, please unmute your mic.
Good evening, sir. Aruna, sir.
Yes, madam.
Sir, you said that Order 41, Rule 19, dismissed for default. It's only for appellant or
If
even
its
for
appeal is dismissed for default, you can ask for rehearing of the appeal. But suppose the appeal is heard without hearing you, you have been set ex parte in the appeal, then in that case you can also be heard and take help of Order 41, Rule 19. Please, it applies for both the parties.
Okay, sir. Thank you very much.
Welcome.
Krishna Mohan garu, మీ డౌట్ అడగొచ్చు సార్ డైరెక్ట్ గా. కృష్ణ మోహన్ గారు,
ఎవరండి?
కృష్ణ మోహన్ గారు చాట్ లో మెసేజ్ పెట్టారు. కౌంటర్ క్లెయిమ్ వేయడానికి లిమిటేషన్ మరియు రీజాయినర్ వేయడానికి లిమిటేషన్ ఏమైనా ఉంటుందా?
దేనికి
ఇష్యూస్
limitation?
ఫ్రేమ్ అయ్యాక వేయొచ్చా?
దేనికి limitation?
కౌంటర్ క్లెయిమ్ కి రీజాయినర్ కి
See, as far as counter claim is concerned, the limitation is when you file the written statement. On the day when you file the written statement, the counter claim has to be raised, number one. And the claim made by you by way of a counter should be within limitation on the day when you file the written statement. And please remember, you cannot file a counter claim separately, written statement separately. It should form part and parcel of the written statement which you file. And once you file a counter claim, you must take the permission of the court under Order 8, Rule 6A to raise a counter claim. And the plaintiff has got a right of filing additional written statement. There is limitation is on the day when you file the written statement, on that day your claim should be within time.
హలో
Yes. Yes, sir.
సార్ ఇప్పుడు మేము డివిసి అండ్ 498A కింద మేము వైజాగ్ లో ఉంది సార్ కంప్లైంట్
Right.
పుష్ చేసాం అక్కడ ఎఫ్ఐఆర్
Right.
ఎంసీ కూడా అక్కడ ఉంది.
Right.
ఇప్పుడు వచ్చి ఉమ్మన్ వచ్చి ఇక్కడ వైఫ్ రిసైడింగ్ అట్ శ్రీకాకుళం.
Right.
ఇప్పుడు ట్రాన్స్ఫర్
You want to, the High Court cannot do it. You will have to file it before. Where is it pending, sir?
పెండింగ్ వైజాగ్ సార్.
Vizag. Then you want it to Srikakulam, isn't it, sir?
వైఫ్ ఈజ్ రిసైడింగ్ అట్ శ్రీకాకుళం.
Yes, you can approach the High Court, sir.
హైకోర్ట్ ఆర్
Yeah, only High Court, sir. Because from state to state, it is the Supreme Court. If it's from from one district to another district, it's High Court.
హైకోర్ట్ ఓన్లీ డిస్ట్రిక్ట్ కోర్ట్
Yes. Yes, sir.
లోయర్ కోర్ట్ చేస్తే నాట్ కదా సార్.
High Court, High Court.
ఓకే సార్.
Welcome.
సార్ వ్యాలిడిటీ ఆఫ్ టెంపరరీ ఇంజెక్షన్ సార్.
The validity of temporary injunction is it subsists till the disposal of the suit. It subsists till the disposal of the suit. Am I making myself clear to you, please?
ఓకే సార్.
Yes.
Good evening, sir.
Good evening. Yes, please go ahead. Yes. Yes, sir. Don't feel shy of asking the question, sir. Please try to clear your doubts.
కృష్ణ మోహన్ గారు, మీ మైక్ అన్మ్యూట్ చేయండి సార్, మీరు మాట్లాడండి, క్వశ్చన్ అడగండి.
Good evening.
Good evening, sir. Good evening, sir.
సార్ ఇప్పుడు రిజైండర్ వేయడానికి ఇప్పుడు డబ్ల్యూఎస్ వేసారు, వేసిన తర్వాత మనం రిజైండర్ వేయడానికి ఇష్యూస్ ఫ్రేమ్ చేసినప్పుడు కూడా వేయచ్చా?
ఎప్పుడన్నా వేయచ్చు, కానీ రిజాయినర్ నార్మల్లీ ఇస్ ఫైల్డ్ ఆఫ్టర్ ద రిటర్న్ స్టేట్మెంట్ ఇస్ ఫైల్డ్, సార్. దట్ ఈస్ ద కరెక్ట్ టైం వెన్ యూ షుడ్ ఫైల్.
తర్వాత ఇష్యూస్ ఫ్రేమ్ అయినాక కూడా వేయచ్చు.
ఇష్యూస్ ఫ్రేమ్ అయినాక వేసేదానికి అవకాశం లేదండి, ఎందుకంటే రిజాయినర్ వేస్తే దాంట్లో కూడా కొన్ని ఇష్యూస్ రేస్ అవుతుంది. సో బెటర్ టు ఫైల్ ఇట్ వన్స్ ద రిటర్న్ స్టేట్మెంట్ ఇస్ ఫైల్డ్. దేర్ ఇస్ నో పీరియడ్ ఫిక్స్ ఫర్ ఫైలింగ్ రిజాయినర్. That is called alternate additional pleadings under Order 8, Rule 9.
Okay, sir. Thank you, sir. Sir, ఇంకొకటి సార్.
Right.
సార్
Ask me, sir.
సార్ ఒకటి కేసు ఫైల్ చేసిన తర్వాత ఒకటి డాక్యుమెంట్ నల్లైన వేయడం అడగలేదు, దాని తర్వాత ఇంప్లీడ్ చేయమని అడగడానికి ఉంటుందా అని ప్రేయర్ లో తర్వాత ఇంప్లీడ్ చేయమని
ఏం అడిగారండి? ప్లీజ్ బి క్లియర్.
ఫైల్ చేసిన తర్వాత అది డేట్ ఆఫ్ నాలెడ్జ్ మళ్ళీ ఒక డాక్యుమెంట్ అయిందని తెలిసింది, దాన్ని నల్లైన వేట్ చేయాలని చెప్పి అలా ప్లీడింగ్ లో మళ్ళీ
I want to introduce, but please remember that can be done by way of an amendment only before the issues are framed or the parties file their respective affidavits. Before that, you must file, because Order 6 Rule 17 bracket 2 says once issues are framed and evidence affidavits are filed, amendment cannot be allowed as a matter of course.
Before framing of issues.
Before issues, exactly. And along with that, you are also supposed to mention the consequential amendments which you have to make in the plaint under Rule 28 Civil Rules of Practice.
Okay, sir. Thank you, sir.
Srinivas garu, unmute your mic, sir.
Sir, good afternoon, sir.
Please go ahead.
Sir, ఒక సివిల్ సూట్ లో నేను రెస్పాండెంట్ అడ్వకేట్ సార్. సార్ అయితే మా రెస్పాండెంట్ ఏంటంటే ఒక 50 ఏళ్ల నుంచి ఒక ల్యాండ్ లో ఉన్నాడట. అయితే ఇప్పుడు పిటిషనర్ ఏం చేసిందంటే అతను మొత్తం ల్యాండ్ అంతా కూడా ఆయన పేరు మీదకి మార్పించుకున్నాడు. ధరణి పోర్టల్లో ఎక్కిండు, తర్వాత ఇప్పుడు వస్తున్న ఇన్సూరెన్స్ అవన్నీ కూడా తీసుకుంటుండు. మా క్లయింట్ దగ్గర ఏం డాక్యుమెంట్స్ లేవు, అంత నమ్మకం మీదనే నడిచింది. ఇప్పుడు నేను కోర్టులో ఏ విధంగా కొట్లాడచ్చు?
You must ask the other side to Order 11 Rule 14 kinda. You must ask the other side to file all those documents into the court and give you copies of that. Order 11 Rule 14, you must address a notice to the opposite side advocate to direct his client to file the necessary documents what you want.
Okay, sir. Then after I want.
But you need not bother about it also. Dharani is being scrapped.
Sir.
And whatever entries have taken place, they're all being relooked at by a new committee.
Sir.
Right?
Okay, sir. Thank you.
Next, please.
స్టే పిటిషన్ కొంచెం చెప్తారు సార్?
స్టే పిటిషన్ ఏంటంటే, suppose let us say you file an appeal, then let us say the lower court has ordered your eviction and you want that eviction to be kept in abeyance till your appeal is heard. Then in that case it is called a stay. Then you request the court to stay the execution of the eviction warrant till the disposal of the appeal. That means you want it to be kept pending till such time the appeal is heard and decided. That is what is called stay.
సార్ వాయిస్ అంత రీసౌండ్ వస్తుంది.
అదే సార్, అది చూస్తాం మేడం, అది రీసౌండ్ వస్తుంది. ఎక్కువ.
Sir, can you please perpetual injunction explain?
See, as far as perpetual injunction is concerned, based on the facts and documents and also the respective evidences that are led on both sides, the inconsistencies, contradictions and admissions made in the course of the evidence in cross-examination and the case law that has been cited by both the parties, the court gives its findings on each and every issue, decides it in the affirmative or in the negative, then a judgment is passed. And if it is passed finally after evidence and arguments, it is called a perpetual injunction. Perpetual means forever. It's called a judgment in rem also. It applies to the entire world, please.
Thank you.
Next.
Yes, Gausia from Madanapalli.
No, sir, I have
You don't have any doubts today.
Yes, sir.
I'm really obliged. Thank you.
Sir, stay petition, sir. Please explain, sir. When you are saying resound, sir,
I'm sorry. Stay petition means where you want the judgment and decree of the lower court for any relief, let us say, to be stayed or kept in suspended animation till your appeal is disposed of, it is called a stay. Are you able to understand, please? That is, things stand where they are. Am I making myself clear to you, please?
Okay.
Yep.
So shall we conclude the class today? Any more questions?
All right. See you again. Thank you.